We're going to start back up with our third keynote speech. We've talked about the District Court Patent Office interface, and we've talked about the District Court ITC interface, and on our next panel we're going to talk about the interface between the District Court and the Court of Appeals for the Federal Circuit. And to lead off, we have a keynote speaker who is uniquely suited to lead that panel. In fact, she could be the panel because she served on the District Court for the Northern District of Ohio as a Clinton appointee for a number of years and heard quite a few patent cases in that time, and then was appointed by President Obama to the Federal Circuit, where she's been serving for the past 3 years, and so has a perspective both from the District Court and from the Court of Appeals. Please welcome Judge Kathleen OMalley.
Okay, first actually, it may seem like I've been there a long time, but it's only been 18 months, believe it or not, since I've been on the Federal Circuit. And I would begin by doing like other panelists did, which is to say that the opinions I'm going to express are mine and not those of the court. But anybody who knows the other members of my court know that they wouldn't let me speak for them if I wanted to. So I don't think that needs to be said. Now, Mark's right. Before coming to the Federal Circuit, I was on the district bench, and I was on the district bench for 16 years. And it was kind of a wild ride. I mean, while we did patent cases, we did a lot of other things as well. And in our court, we didn't have anything like the patent pilot program now. So not only could you not opt in to try more patent cases, but most of the judges on our court disliked patent cases so much that we had them on a separate deck. Patent cases were equated with death penalty cases in our court. So that we had those two on a separate deck. So you'd have to draw through every judge before you could get a second patent case, and draw through every judge before you could get another death penalty case. So that meant that we did a lot of things. And just to give you some examples, in the 2 years before I went on the Court of Appeals for the Federal Circuit, I presided over both the criminal and civil fallout of a massive Ponzi scheme, a la Bernie Madoff. In fact, they used some of our orders in the Madoff case when it ultimately hit. I presided over all of the activities relating to the U.S. Attorney's investigation, public corruption investigation of public officials in Cuyahoga County, where my court was located, which included several lengthy trials, as well as guilty pleas and sentencings of about 40+ individuals, including public officials, public contractors, judges, lawyers. It was unbelievable, the breadth and depth of the corruption in Cuyahoga County. I presided over a death penalty case where I actually set aside the conviction, not just the penalty, but set aside the conviction and barred re-prosecution because of massive prosecutorial misconduct. I tried just in that last 2 years, I tried 3 jury trials, bellwether jury trials, in one of my multi-district litigation mass tort cases. I tried a couple bench trials in a commercial multi-district litigation. In other words, there was a lot that I was doing that had nothing to do with patent law. Now, I tell you all this not because I want you to pat me on the back for having done the job that I wanted to do and was privileged to do. And I don't tell you all this to make you envious, though, frankly, as Jeremy and Lucy and others, and Judge White, if he's here, where is he? As they all know, being a district judge is a really great job. So you should probably be a little envious based on the kinds of things that district judges get to do. But I tell you this because I had some fear, some trepidation about giving up that district judge job and moving to Washington. Anybody who knows me knows that I have had a personal reason for wanting to move to Washington. It happened to be convenient since my husband lived and worked in Washington, so that we could end this long-term commute. I also thought that the Federal Circuit really could use a district judge with some experience in patent litigation. Not necessarily me, but a district judge on the Federal Circuit. And I had a little bit of fear that after 16 years, that there might be some burnout. I had another 12 left. I was looking at another 12 before I could get to senior status, so I was afraid that continuing to put young men in jail and hearing porn cases and you know, watching plaintiffs' lawyers bring frivolous suits and defense lawyers refuse to settle non-frivolous ones, that after a while I might become that judge that everybody hated, the one that was not quite patient enough, not quite caring enough, not quite governed by the rule of law enough. So I put all those things together and said, I think I'll try to go for this spot. And as you can tell, because I'm here, it worked. So I'm now on the federal circuit, but as I said, I had some fear about moving to Washington. Not fear about living with George, that was okay, but I was afraid that the life might be a little monastic, that it would be so quiet after all of those activities. It turns out that I have come to the court at kind of an active time. In fact, sometimes I think of that Chinese curse, that may you live in interesting times. Well, it's an interesting time to be on the federal circuit. And I'm just going to mention a few things, and I'm happy to take questions about any of them to the extent I can answer them with the limitations that are now on me in this new role. But just a few highlights. The first is the personnel changes. Probably why Mark thought I've been on this bench for 3 years is because I've already moved up in seniority. There are 2 judges below me already on the court and a 3rd in the pipeline. So, I mean, the last new judge was the new judge, meaning the first one to speak at conferences and the one who opens the door and all that, she was the new judge for 5 years. The judge before that was the new judge for, I think, 6 years. And I was only the new judge for a few months before all of that started to change. And the one after me, Judge Reyna, was only the new judge for a few months. So we've got, so there are a lot of personnel changes happening at the court. We're hoping that Richard Taranto will be confirmed soon, so there'll be 3 below me, which means my chance of presiding very soon are very high, which seems very rapid for those other judges that had to wait forever for that. I think Judge Moore just presided for the first time in the last month. So, and we're expecting at least 1 vacancy this year, maybe 2. Certainly within the next year from now, we'll likely have 2 vacancies. I won't tell you who they are, but we anticipate that. So there'll be more people coming on and more change on the court, both in terms of its personnel and in terms of how the judges will interact and what their attitudes will be. I'm also on a court, I came on the court about the same time that Judge Rader became chief. And if anybody knows Judge Rader, you know that he has one speed, and that is frenetic. He has got us involved in all kinds of initiatives. Luckily, we finally announced that we went on to CMECF, the electronic filing. Having come from the district court, where ours was the first court in the country to be in electronic filing, and I lived with it for 12 or 13 years, I felt like I'd gone into the dark ages when I went on to this high-tech court. So we've got electronic filing coming in. We have, with the help of our advisory committee, Ed has helped us out in that. We have the EDiscovery Order, which is designed to limit e-discovery, and we're hoping everyone around the country will start to adopt that order. It's pretty revolutionary, actually. We have also, Judge Rader has us all doing a lot of interaction and crossbreeding with judges who do what we do in other countries, so that we can encourage active enforcement of patent rights and intellectual property rights in other countries where they're less inclined to do it, so that maybe we can learn some good practices from other countries that have been doing it for a long time. And he's got, in fact, the whole court, other than me and 1 or 2 others, are going to China at the end of this week. I'm not going to China because, as I said, I have my priorities straight. One of my law clerks is getting married, and I had promised him. He gave me 2 years' notice. What could I do? So I'm going to the wedding instead, much to the chief's chagrin. It's also a time, as you've heard, and I won't go into detail on, of the AIA. I mean, we will have, everybody's talking about all the PTO's new rules and everything they're going to do, and we're standing back petrified about all the cases that are going to come up to us, and we're going to have to interpret all of these provisions. It also expands our jurisdiction There's a piece of the AIA that gives the court jurisdiction over even patent cases that are asserted in counterclaims. So there's a lot that is going to be happening under the AIA and because of the AIA, and those are changes we're going to have to adapt to. We have the patent pilot program, which you've heard about, the judges, the district judges around the country who are now opting into the patent pilot program. We had a meeting, as Jeremy said, with these pilot judges in conjunction with our judicial conference. And the interaction, just like the interaction today, has been great, or it was great. We got to hear what their concerns are. I think they used the word deference, 30, 40 times, maybe? But it was a good interaction between those judges and us. I think it always helps to understand who's deciding the cases above you, who's deciding the cases below you. You understand exactly what they go through. It helps me remember from whence I came, since I'm supposed to be the one representing the district judges on the court, or at least for the time being. We're also here at a time, I'm at a time, when the Supreme Court seems to be pretty interested in our court, and with good and bad results, I'm afraid. And the Supreme Court is not just interested in our patent jurisdiction, it's paying attention to our jurisdiction in other areas as well. They recently took a takings case, and there's some debate among us on the court about what the takings law should be, and we do a lot more takings cases than most other jurisdictions, so it'll be interesting to see where the Supreme Court comes out there. I do have one piece of defense of us, though. I keep hearing repeatedly, and I heard it during the program in Washington last week, that we're now the new Ninth Circuit because our reversal rate is so high. But you have to remember, in fairness to us, that we don't have another circuit to have a circuit split with. I mean, when the Supreme Court takes a case, very often there's a circuit split. So one circuit's going to be right and the other circuit's going to be wrong. They don't have much incentive to take our cases unless they want to reverse us. So while our reversal rate is high, it's understandable that it would be the rare case, like the Hyatt versus Kapos case, where I think the Supreme Court probably took the case to reverse us and changed its mind and saw our brilliance after it got up there. But so yes, our reversal rate's high. I don't think that will change, and I don't think it necessarily reflects the quality of our decision making. I also came to the court at a time when there was lots of en banc activity. I mean, when I came on, we had TiVo and TheraSense. We also had two other en banc cases, Clower and Bush-Shelton, one a tax case, one a Vaccine Act case, that were also very, very well-watched cases and very important cases. So I came on with 4 already pending and participated in all 4. We then did Akamai McKesson, and I can't comment on that one, and as some of you may have seen, we just took the beer case on Friday, which is the judge's pay case, or as the judges like to call it, the judge's, pay restoration case, because some of you may not know, but the judiciary is watching this one, because Congress had a number of what we call blocking statutes, where they actually entered a statute just to prevent us from getting a COLA for many years. So we've taken that case en banc, so we're putting ourselves right in the crosshairs. We're either going to disappoint the entire judiciary or get Congress really upset with us, but either way, we didn't at least duck from it. So there's a lot of en banc activity, and those are very time-consuming and very active. There are a few other things that are also going on. We've got, in connection with substantive areas of law, we've been kind of active on the mandamus front in the last year or two. We've been mandamusing not just the Eastern District of Texas. I know they think they're the only ones who get mandamused, but we've been issuing mandamus cases to order transfers of jurisdiction. We had the In Re EMC, where the mandamus came out with respect to joinder, pre-AIA joinder, making it clear that it is a 2-prong test and you have to have both prongs satisfied. You have to have not only overlapping questions of law or fact, but you do need the same transaction or occurrence in order to have joinder. So I think that's going to have a big effect, especially on that whole flood of cases that got filed in the days leading up to the AIA. We've had some changes, as you'll hear from the panel, in the area of damages law. There's been a lot of changes. I mean, Unilock was a big issue, a big decision, and I think that it was pretty well received by most people. But it's certainly made a big change. There have been other damages cases that where we're also, we've also made some changes in the development of the law. I think we've clarified some with respect to injunctions. I'm proud that I was part of that. We've clarified some issues there. We've clarified some issues with respect to obviousness and the importance of objective indicia in the obviousness inquiry. And we've got 101 going on, which I know we're going to talk about on the panel to some extent, but that issue has got everybody pretty busy and trying to figure out where the Supreme Court's coming from. As many of you probably heard, the Supreme Court GVR'd another case, Ultramercial. That was one that the chief wrote that I was on, where we had found that something was patentable subject matter. This one in the software area, and they sent it back in light of Prometheus because they think that that was so clear, I guess, and that we know exactly what to do with it. So, so we've got a lot of those issues that we're going to be struggling with. I happily am recused from the Myriad case, so I don't have to fight with the first battle, the first place that they struggle with it. And we're also seeing some changes in the kinds of cases and the kinds of patents we're seeing. We had a discussion recently over one of the judges' lunches where we realized that we're all seeing a lot more design patents. And I think that design issues are becoming more and more important because as technology changes so fast, for some companies, the designs are going to be the thing that set them apart. And so we're all seeing many more design patents, and I think that's going to continue. I looked at some statistics that one of my law clerks pulled for me, and in 1975, there were 5,000 design patents issued, and in 2011, there were 30,000 design patents issued. So you guys are busy, I guess, or that's the numbers they gave me anyway. So we're seeing some shifts in the kinds of cases that we're getting. I think we've resolved some issues so that have made some things clear, more clear, I hope, in certain areas. So we're not seeing as many of battles in those areas where the law has been pretty well settled. But it is a fast-paced time to be on the court. I do miss my district court job. Now, instead of sitting behind the bench, I'm sitting more at my desk than I used to be. But it is certainly not boring, and so my fear and trepidation. In fact, I don't even have time to think about being afraid because they have us so busy there. So I'm happy to talk about any of these issues. I just wanted to sort of lay out some of the things that are going on. Anybody have any questions? Okay, yes.
Please head to the microphone if you don't mind.
You mentioned the model order on e-discovery. I've succeeded in having it adopted in cases here in the Northern District, less successful in other places, and I'd just be interested in hearing what kind of feedback you've gotten, either from district court judges or practitioners about having that adopted, because I do agree it does streamline the discovery process a massive amount.
The response has been good. Ed Reitis can tell you as well, because he's gotten a lot of the feedback. It's been surprisingly well received. When I say surprisingly, I mean we're not getting even a lot of pitched battles from those who are normally on the plaintiff's side. I think everybody realizes that it was an area that needed to be reined in. I know that some of the judges in the Eastern District of Texas adopted it early on. They now have their own version of an EDiscovery order that follows the model pretty closely. There's a few things that they tweaked. But I think it is getting, it's, you know, it's new. It was only about a year ago when it was rolled out. Is that right, Ed, about a year ago? September at the Eastern District of Texas conference. The chief thought that would be an appropriate time to roll out limits on district court practice. And so it was only in September, and yet it's getting some traction. And the district judges that were there with the pilot program were very interested in it, and a lot of them are from districts that already have default orders in place, so they can't necessarily just adopt this one without getting the vote from the rest of their court members. But I think that they're certainly interested in using this one to replace the default models that they have in place. Anybody else? Okay, so we can move on.